City. Welcome, honorable speakers, ladies and gentlemen. I, Mr. Rudranarayan Das, on behalf of the organizers, extend my heartfelt welcome to all to this international conclave. This Ranjit Guru series of international webinar is an initiative by the Department of History and Political Science, Jawaharlal Nehru College, Cuttack, in a close collaboration with Center for Adivasi Research and Development Studies, Odisha. I feel happy to express that we have successfully concluded the 117th round of panel discussion yesterday. In today's session, I feel extremely honored to introduce our guest speaker, who are none other than Professor Gloria D'Souza and Professor Isaac Emanuel. It's a pride privilege to host all of you, ma'am. The broad theme of our international webinar is kept as Initiative Policy Dialogue 2020, COVID-19, and Live Practice Beyond Pandemic. Thank you. Now I would like to invite the convener of the webinar, Professor Sarath Pradhan, to initiate a welcome address for our guest. Over to you, Pradhan. Professor Pradhan.
Thank you, Rudranarayan, for inviting me for guest introduction or welcome address. Learned scholars, participants, academics, and distinguished guests from university and academia. I welcome you all to this academic exposition. Friends, the farmer is the only man in our economy who buy everything at retail, sell everything at wholesale, and pays the freight both ways. There is a saying, no race can prosper until it lures there is as much dignity in tilling a field as in writing a poem. So, farming is a profession of hope and backbone of our society. So, we have to recognize that everyone serves an important role in society, from farmers to rulers. We are all important. In 2001, Indian Parliament passed an act for the protection of plant varieties and farmers' rights. This act enacted to provide for the establishment of an effective system of protective of the plants varieties, the rights of the farmers and the plant breeders, and to encourage the development and the cultivation of new. Today's topic, plant varieties and farmers' rights, is very thought-provoking and time-testing. We are glad that in order to throw more on the theme and to have more academic exploration, enriched and erudite academicians have joined with us. I extend a warm welcome to Gloria D'Souza, Special Counsel at Anderson and the Associate LLP, New York, USA. Friends, all human beings are born free and equal in dignity and rights. Everyone is entitled to all the rights and freedoms set forth in the Universal Declaration of the Human Rights, without distinction of any kind of such as race, creed, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status, everyone has the right to life, liberty, and security of the person. Today's topic, human rights, as the basic for the software development, is very interesting and thought-provoking. I take this opportunity to extend a warm welcome to the Professor Isaac Emanuel, legal researchers, Mexico, North America, to enlighten the assembly. Also, it is my privilege to welcome Professor N.S. Srinivasulu, Professor of the Law, National University of Judicial Science, Kolkata, Dr. Vikram Kishori Jena, Director, Center for Adivasi Research Development, Odisha, for their hearty cooperation. Hope all of us will be significantly enlightened by the eloquent deliberation of our learned resource person. Thank you all.
Thank you, Professor Pradhan, for your wonderful welcome address. Now, I would like to invite Ms. Payal Agarwal for a brief guest introduction.
A very warm greetings to one and all. I am very happy to introduce our guest speakers for today's webinar session. Our first guest speaker is Professor Gloria D'Souza. She is a special counsel at Anderson and Associates LLP, New York, USA. Beginning her legal career as a lecturer in Mangalore, she immigrated to US in 2003. Her passion to work for immigrants makes her very sensitive towards such issues. Thereon, she assists individuals and corporate clients in various industries on various immigration matters. She herself has practiced immigration law with some of the leading IT and management consulting firms in the United States of America and Canada. Thanks, ma'am, for connecting with us way far from United States of America. Ma'am will put her insights on plant varieties and farm. Speaker is Mr. Isaac Emanuel. He's a legal researcher, Mexico, North America. He's now working as a legal coordinator in real estate and food product entrepreneurship. More so, he's a person who is proactive and committed to activities he performs and is quite passionate about technology as an area of opportunity in laws. So, we welcome you for this lecture session. Sir, your topic as suggested by you is human rights as the basis for software development. Last but not the least, our speaker is Professor Srinivasulu. He is also the key advisor of Center for Adivasi Research and Development, Odisha. He is currently working as a professor of law, National University of Juridical Sciences, Kolkata, India. He is also a member of International Council of Jurists, London. We welcome you, sir. Sir, your topic as suggested by you is Adivasi issues and information technology revolution. Now, I would like to stop here and invite Gloria ma'am to please initiate her talk. Over to ma'am.
Sure. Thank you so much. Thanks for inviting me, and I'm really happy to collaborate with you all. Are you able to see my screen?
Yes, ma'am. Yes, ma'am. We can see
Hello?
it. We can. Yes, ma'am. Yes, ma'am. Your PPT is visible. ତାଙ୍କର କିଛି ହେଲା ସେ still ହେଇକି ରହି ଯାଇଛି ନିଶ୍ଚିତ ଅନମ୍ୟୁଟ ଅଛି ସିଏ ଅନମ୍ୟୁଟ ଅଛନ୍ତି ତ ma'am, you are muted. You need to require unmute yourself.
Payal.
Yes, sir.
Payal Agarwal.
Yes,
Why
sir.
don't you ask her to send her Why don't you ask her to send her PPT to you so that you can run the PPT?
Okay, sir. I'm doing that. Okay, sir. Thanks, sir.
Yeah. And if she is still finding some digital connectivity issues, ask her to set that right, and I can initiate my talk in the meantime. Ask her, because if it is going to take time to set her things right, yeah. Since she's
Excuse me,
finding
Gloria,
it,
ma'am. Ma'am, if there is any issue in PPT, so you can send the PPT to us. We can present that.
Gloria D'Souza, whether we are audible to you. Text her if her voice is not reaching. Text her on WhatsApp.
In the chat. रखे थे वीडियो ओके I think there is some issue with the Gloria ma'am. So now I'd like to invite Professor Srinivas to please initiate his talk. We can have a talk of Gloria ma'am later on, a bit later. So now I'd like to invite Srinivas to please initiate his talk. Over to Srinivas sir.
Yeah, I will initiate my talk, but in the meantime, you try to fix her connectivity issues and get her PPT so that things can go smoothly during my talk.
Yes, sir. Sure, sir. Thanks, sir.
Yeah. Thank you, Payal. Thank you, Rupam. Thank you, Nehru College, Cuttack. Thank you, Bikram Jana, my friend from the Center for Adivasi Research and Development. And this topic, the broader theme of today's topic, human rights, IPR and Adivasi is very close to my heart, and it's in fact my brainchild. In fact, I wanted to have this session exclusively with the presence of my colleague Gloria D'Souza, who is from New York, who happened to do her PhD under my guidance of late. And the topic that she has chosen is actually the thesis of Ho, which she worked under my guidance. And also our friend from Mexico, who is also speaking on certain issues connected with the information technology and human rights. That also we are in a way looking at using technology for enriching the human rights of Adivasis, right? So Adivasi human rights and intellectual property rights is the basic theme. People may not believe that intellectual property rights are actually offshoot of human rights. The creativity, the expression, the innovation, the patents, the copyrights, all that is actually part of human rights dichotomy. Every one of us will have human rights. Similarly, Adivasis would also have their own human rights. And these human rights are actually giving way for intellectual property rights. Every individual would like to have his or her say heard. Every individual would like to lead the dignified life. Every individual would like to do their own experimentations with technology, what skill, expertise they have acquired. And every individual would like to use the sophisticated technology. So use of technology, conferment of intellectual property, creativity, innovation, all that is because of your natural virtue. Every individual wants to express, every individual wants to explore, right? So your natural interest to express and explore is the reason for use of technology, invention of technology, conferment of intellectual property rights. And Adivasis are not divided of that. But the most civilized societies, the big cities and all, where we think in terms of the noted fact that intellectual property rights or technology is basically meant for those people who are more civil, who are into society, and people who are forest dwellers, people tribal Adivasis, farmers, they do not have anything to do with the technology or with intellectual property rights. This is the classical and much popular belief, but it is not true. The intellectual property rights or technology aspect for that matter is not just confined to the usage of people who are most civilized, who are in big cities. Intellectual property rights are actually equally applicable to the Adivasis, and in fact Adivasis are having more stake in intellectual property. Adivasis are having a bigger stake in technology because they are downtrodden, they are not forming part of the mainstream populace, and you need to give them special assistance, and you need to pull them, push them to join the mainstream. So more than the people like you or me, more than the people who are the so-called civilized people, technology assistance, intellectual property innovation is much more required for Adivasis to ensure that their right to dignified life is perhaps fulfilled. To give them access to technology, right? We talk about access to information, access to technology. This access to information, access to technology is not confined to the people like you and me, but the same right is possessed by Adivasis also. Whether we are ensuring them the right to access to information, whether they are getting the information properly, whether they are able to access to technology, whether they are able to use the technology in the sophisticated area. I'll give an example. We all talk about 3G, 4G, and nowadays we are talking about 5G also in big cities. What about even 2G in tribal areas, forest areas? Is it not the way that people are treated in a like a second-rated citizen? If you are using 4G, 5G technology, use it across the globe, across the country, right? Pan India. Why you are confining the same to only big cities? That means you at the government level itself, you have decided that the most sophisticated technology shall be given only to the people who are in metros, only to the people who are most civilized. And these people, farmers, tribals, or Adivasis, they do not need any technology sophistication. That's the reason why in most of the tribal areas we don't get to see even the towers of mobiles, right? They don't get signals also. So forget about internet, forget about any other technology, forget about conferment of patent, copyright, or whatsoever. So the point that I'm trying to say is the sophisticated usage of technology and ensuring that decent, dignified right to development we are facilitating for the people of India is a big farce. You are only doing that for ensuring market access to multinational corporations, and you are only keeping in mind the people who are in big cities. You are forgetting and you are ignoring, and you are giving a second-rated citizen treatment to these people because there is no access to technology, there is no access to information, there is no access to intellectual property rights, and there is no proper, decent, and dignified life whatsoever that you are guaranteeing to Adivasis. That's why this talk, this session in particular, right, alongside my lecture and the other two lectures, we are trying to steer in that way that what is the contribution of technology for the fulfillment of human rights of the masses and in particular Adivasis. Whether technology sophistication, technology access, technology development is helping out the Adivasis in any way. Whether you are able to use technology for bridging the gap between the Adivasis and mainstream economy. Whether technology sophistication can do miracles, better things for ensuring decent and dignified life of Adivasis. Whether conferment of plant varieties, conferment of intellectual property rights, patent, copyright is able to ensure that tribals and Adivasis are getting some livelihood. Whether tribals and Adivasis are able to get their 2 staple meal per day. Right? So what kind of governance we are into, especially in terms of intellectual property rights, human rights, and technology access, these 3 aspects, whatever we have taken up for today's session, through these 3 aspects, whether we are able to reach out to Adivasis, whether these 3 aspects can help us in reaching out to Adivasis by conferment of intellectual property rights, by ensuring human rights, and by showing technology access, by ensuring technology access or sophisticated technology usage. Can we guarantee decent and dignified life to Adivasis? Can we win the heart of Adivasis? Can we bridge the gap between Adivasis and the sophisticated civil society? That is the basic theme of the current session, right? So when I talk about intellectual property rights, people think that intellectual property rights are generally meant for multinational corporations, big scientists, big technocrats, and big businessmen. Right? This is what the most established classical belief with reference to intellectual property rights is all about. That may be true also, because to an extent, if not completely, it is largely true, because most of the intellectual property rights, ranging from your patent, copyright, and trademark and things like that, have been conferred to multinational corporations and big people only. Ambani's, Adani's, Mittals, Kiran Majumdar's, Infosys, right? Like these big companies are getting intellectual property rights. Are sophisticated people, are educated people like you and me who are living in metros, they are getting intellectual property rights. But intellectual property rights purview marketing is there pan-India. In fact, in entire world, the individuals or corporations who are going to get the intellectual property rights, they are going to have market across the globe, including the forest lands, including the lands of the tribal people, right? But the fact that whatever type of intellectual property that you are actually trying to confer to any particular individual or particular multinational corporation, there will be a public interest concern attached to it, installed with it, right? Public policy concerns involved with it, saying that in case of any emergency, in case of any requirement of generic use, such a type of patent, copyright, or for that matter trademark can be acquired back, can be taken back by the government. Now, I'll give one example. In case of any pandemic, or in case of any public emergency or exigency, Government of India can require those multinational corporations or individuals who have obtained a patent, copyright, and trademark to be given, to be suspended, to be given free of cost to the people, right? Alongside that, there are certain spheres of intellectual property rights like geographical indications, like copyrights, like plant varieties, where Adivasi people can obtain intellectual property rights. You may not believe me, but it is true. If you look at the copyright law sphere, right, there is a scope for protecting Adivasi expressions. When I say Adivasi expression, I mean folklore, right? Folklore, which is nothing but Adivasi writing, Adivasi expression, or the writings, culture, heritage of our Adivasi tribal people that can be given protection under copyright law. There is a possibility of giving protection for such a type of Adivasi expressions, Adivasi cultural exposure, and Adivasi literature writings, all that can go under copyright law. You may ask me a question, what literature Adivasis can produce? The literature pertinent to use of resources, literature pertinent to living close with the nature. Who knows better than them about the nature, right? Who knows better than tribal people about the nature? So you can learn from them how to live close to the nature. You can learn from them what type of forest resources, biological resources are useful for the mankind, consumable food, and also as medicine, right? Adivasi medicine, Ayurvedic medicine, tribal medicine, right? That kind of knowledge we can generate from them, learn from them. What we need to do is document it, right? The way they are living close to the nature, the way they are using natural biological forest resources, that can be given some protection, that can be made use of by everybody around us across the globe, you and me, and entire civil society. So can't that encourage? That government of India initiate that people who are little educated, who can win the heart of Adivasis, then go to them, then to go near to them and learn from them how they are living their life in the forest, how they are living life very close to the nature, how they are able to cultivate, how they are able to use the natural resources, right, without any formal technical expertise, without any formal education. That is their traditional knowledge, that is their folklore, that is their art of living, right, that is their culture, and that it can be expressed, which we call as folklore literature, which showcases the way they live, the way they earn their livelihood, the way they live close to the nature, the way they use and utilize natural resources. That literature, that expression, folklore, right? Believe me, there is a possibility of giving protection for Adivasi literature, Adivasi heritage, Adivasi expression, Adivasi culture, wherein if they can produce in black and white or express how they are living the life in the nature, what type of natural resources are useful for agricultural, food, and medicinal purposes for the mankind, that can become a subject of protection under copyright law and under the garb of folklore, right? That is one. Number two, there is a intellectual property sphere called geographical indications, right? People must have heard about basmati rice, Darjeeling tea, like that, right? Or Banaras sari, right? People know these big brands, and these brands are actually having some locality affiliation. Basmati tea from Punjab region, Darjeeling tea from North Bengal region, Banaras sari from say Varanasi, Uttar Pradesh, right? Some product, some special quality, and one particular locality, right? This connection you are talking about in this connection, in this concern. So this is we call as geographical indication under the intellectual property right law. It is nothing but indicating a particular geographical locality with respect to a particular traditional product, right? Basmati rice growing or Darjeeling tea growing or your Banaras sarees weaving is not taught in any university. It is not taught in any college. It has been learned by our Adivasi people in Darjeeling area, our tribal people in the Punjab area, our weavers, people who are in the Varanasi or Banaras area, right? So these traditional products actually produced by our own Adivasi people are learnt from Adivasi people, not through formal education whatsoever, but through traditional knowledge or from handing over of the same knowledge from one generation to other. So this is a typical kind of intellectual property which actually tries to provide protection for traditional products, right? Basmati, Darjeeling, or Banaras sari, and even Odisha happened to obtain very recently Rasagulla protection, right? Odisha version of Rasagulla, and Bengal is also having their own version of Rasagulla, right? Kanchivaram sarees, Mysore silk, Mysore pak, right? Nagpur oranges, like that, Kashmiri apple. All these things are well known to everybody. But unknown fact is that these products are actually produced through usage of traditional knowledge by our tribal people. The production, you may call it as agriculture, horticulture, or whatever may be the culture, by virtue of which you are able to produce all these types of products, Kashmiri apple, or for that matter, Darjeeling tea, Nilgiris tea, Assam tea, right, Basmati rice and all. It is not that the technique, expertise of growing these things is not taught in any university or college. It has been learnt from the traditional knowledge. Who have taught them? Our own forest dwellers, our own Adivasi people. And for that purpose, to recognize this kind of traditional knowledge created by Adivasi people, supported by Adivasi people, gathered, garnered, and cemented by Adivasi people, we have a special intellectual property regime called geographical indication. Geographical indications law came into being in 2003. In the past 17 years, government of India has given registration or protection to 500 such tribal products. Please remember, 500 such tribal products have been given intellectual property protection by the government of India, wherein all our Adivasi people, Adivasi communities, tribal associations have acquired intellectual property. Now, Darjeeling Tea Growers Association, who grow Darjeeling tea? Our tribal people in the hill regions of West Bengal. Who grow Assam tea? Our tribal people in the hill region of Assam. Who grow Nilgiris tea? Our tribal people in the hill regions of Tamil Nadu, right? Basmati, similarly, our tribal people in the Punjab or Sindh area, right? So ultimately, this knowledge is possessed, acquired, created by tribal people, as a result of which you have got this kind of special products having some unique quality, some goodwill, and that goodwill is associated with a particular locality, and that particular locality tribal people are the reason for guaranteeing that quality, or that locality tribal people are the reason for germinating that knowledge, or are compiling that knowledge and handing over the same knowledge to next generation. I repeat again, it is not taught in any college or university. It is a tribal knowledge. It is a traditional knowledge. And to ensure that this tribal knowledge, traditional knowledge is not conquered by any multinational corporations or private individuals like you and me, Government of India, what it has done? It has said that such kind of geographical indicating products, say your Darjeeling tea, Assam tea, or Kashmiri apple, or Basmati, no private individual can obtain intellectual property. No multinational corporation can obtain intellectual property. Only tribal people can obtain intellectual property. Only tribal associations can obtain intellectual property. Only our farmer associations can obtain intellectual property. For example, Basmati rice is actually given protection to Basmati Rice Growers Association, a community, tribal community from Punjab. Similarly, in case of your Darjeeling Tea Growers Association from North Bengal, Assam Tea Growers Association from Upper Assam, where it is nothing but a tribal union. It is nothing but the association of our Adivasis, association of our Aboriginal people. They are eligible to obtain. So what we have to do? We have to empower, we have to spread awareness to our Adivasi people that whatever traditional products that you are producing, they are worth protection. Government of India is inviting you to get the same protected, because on those things, nobody else can obtain intellectual property protection but you and your organization. private individuals, people who are in big cities, people who are in multinational corporations, they cannot get any protection on the tribal traditional products like Darjeeling tea, Assam tea, Kashmiri apple, or Nilgiris tea, your basmati rice, or your Banaras sari, or including your Odisha Rasagulla, right? This is in fact, the Odisha Rasagulla's history also says that traditionally, poor Lord Jagannath, the sweet was prepared for conferment to Lord Jagannath, and even that was also initiated by some Adivasi people from centuries back. Very, very historical reasoning is given to the government of India when for obtaining that geographical indications protection, intellectual property protection for the Odisha version of Rasagulla. So what I'm trying to say is, intellectual property rights is not just meant for enriching multinational corporations or private individuals. It is also meant for recognizing the efforts of Adivasi people, like they are making efforts in producing Rasagulla, Darjeeling tea, Assam tea, and things like that. And we have to ensure that our Adivasi people, whoever are there around us, whoever we have got some contact, we should encourage them to consolidate, combine, and compile the knowledge with respect to whatever traditional products they are producing. And for that, there is the protection available under the intellectual property realm, under geographical indications law, right? So under the copyright law, you have folklore protection. That is the knowledge of tribal people, tribal expressions can be given protection under folklore knowledge under copyright law. Now, traditional products can be given protection under geographical indications law exclusively for tribal people and tribal associations. Now, coming to plant variety. In case of plant variety also, you do not have any scope for providing protection to individuals and corporations. It can only be farmers associations, tribals, and tribal associations, right? In case of plant variety, there is also scope for multinational corporations as well to get protection, but even the tribal associations, farmer associations can also get protection. Whenever our tribal people, farmers, they come out with a new variety of a plant, right, by their own natural cultivation or agriculture, whatever practices they are actually into, if they are able to come out with their own new variety, tribal variety, farmers variety, while cultivating any particular plants or while doing the agriculture in their farming lands, if they are able to come out with a new innovation with respect to any plants or plantations that they are into, right, we call it as a tribals variety, traditional variety, or farmers variety, that can also be given protection under the plant variety law. So what I'm trying to say is, under the plant variety system, there is also scope for giving protection to our tribal innovations, our farmers innovations, our Adivasi innovations, especially in the agriculture sector. If our tribals, farmers, or our aboriginal people, if they are into agriculture, horticulture, and things like that, they do nurturing those agricultural products, right? Doing that agriculture or are becoming party to that horticulture, that can also go under intellectual property regimes protection, right? So three different regimes, three different opportunities are there for conferment of intellectual property rights to Adivasis. One is protection of Adivasi expressions under folklore copyright law, protection of Adivasi and tribal products under geographical indications law, protection of Adivasi farmers and tribal varieties under the plant variety law. So you have got three different opportunities for empowering, for recognizing the efforts of our Adivasi people under the intellectual property arena. Right? So unlike the classical belief that intellectual property rights are only meant for private people, multinational corporations, I have tried to present how exactly certain expressions, certain products, certain innovations be given protection under respective intellectual property laws, in particular copyright law, geographical indications law, and also plant variety law. So the misnomer is over now, that tribal people, traditional people cannot get intellectual property rights. They can get intellectual property rights, as I mentioned, under the intellectual property rights law, but they do not know it. Not only they, even most of the people, they do not know. Everybody thinks that patent copyrights are meant for big corporations, businessmen, scientists, and technocrats. That's not true. Even our tribals, farmers, aboriginal people can also get protection of intellectual property under the respective spheres of copyright, geographical indications, and plant variety. And by ensuring intellectual property rights protection for our farmers, tribal people, for their respective cultural expressions, tribal products, and tribal plant varieties, you are actually ensuring their right to livelihood. You are actually enriching their right to livelihood, because when you are actually showcasing, recognizing, and giving some protection to their tribal traditional knowledge and as well traditional products, you are giving them market recognition. You are giving them, sale and purchase capacity. You are pushing them into open market. market. By virtue of that, they are able to earn their livelihood, and by virtue of that, they are able to live their life in a decent and dignified way. So conferment of intellectual property rights to Adivasi people for their traditional products, by virtue of that, you are able to give them market, you are able to give them some money, whatever they are earning, right? That earning is going to give them livelihood. By virtue of that, they're also going to lead a dignified and decent life, right? So there's a fusion between intellectual property conferment to Adivasis and in empowering them or ensuring them human rights. So IPR, intellectual property, human rights, and technology sophistication. These three things can actually better the life of Adivasi, not only in terms of documenting their traditional knowledge, not only in terms of giving marketing rights to their traditional products, but as well in ensuring their right to life, right to livelihood, and right to decent and dignified life. At the same time, providing them access to technology, providing them access to information, right? It could be software technology, it could be biotechnology, or any kind of technology for that matter, which we are making available to one and all the masses of this country. We should ensure that the same shall be given also to the Adivasi people, because they should also be techno savvy. Now, in the past 1 year or so, now the open bank operations are slowly going down. Everybody is expected to have online banking, mobile banking. Then what about tribal and Adivasi people? There, you do not have any mobile tower there. You do not have any internet connection there, right? You do not have a net banking system there. So they're actually lagging behind. You may say that we are connecting entire India digitally, connecting India, all that. But you have not connected your own neighbors, your own tribal people, your own brothers and sisters. So sophistication of technology needs to be done with respect to Adivasis as well. And that is also part of their life. Because nowadays, having access to technology, access to information is part of right to life. Right to information, right to access to technology is part of right to life, right? Without access to information, without access to technology, you cannot ensure anybody's decent and dignified life. The same is with Adivasis, especially in the current context of digital world, digitalization, digital economy, right? Digital mankind, everything is going digital now. Then why Adivasi people should be lagging behind? So we need to ensure, the government of India needs to ensure that this digital sophistication, this digital economy, digitally driven life include Adivasis as well, because they too have their own human right to have technology, their own human rights to explore technology, their own human rights to exploit the technology and make themselves compatible to use the technology. That's why technological sophistication and dignified life of Adivasis can be ensured. So technology assistance can be taken for ensuring decent and dignified life of Adivasis. Intellectual property rights conferment can be done for the purpose of marketing their cultural expressions and cultural products, and at the same time, you can ensure the proper and appropriate recognition and standardization and ensuring of their respective human rights. So there is a serious nexus between intellectual property rights, human rights, and technology as far as Adivasi life is concerned, as far as Adivasi empowerment is concerned, as far as Adivasi's development is concerned. You need to recognize their traditional knowledge under intellectual property rights law. You need to recognize their natural right to gain access to technology, and then only you can ensure their formal, appropriate, and legal human rights with respect to enjoying their decent and dignified life, and also ensuring them that they are having livelihood, earning capacity, marketing for whatever they are doing by living close to the nature, or whatever they are doing by using natural resources in the forest lands or tribal lands, and in that capacity, in that respect, we can learn from them by documenting their knowledge, and that can go under intellectual property. And as a matter of fact, technological sophistication, if it reaches them, then only you can say that this digital connectivity or digital economy has reached the grassroots level. Grassroots level means not ordinary towns and villages. Grassroots level would also include our tribal populace, forest or forest lands. That is the real grassroots, because every individual is having his or her roots in tribal populace only. Entire mankind started his or her identity with as a uncivil, barbaric, or whatever words you call, or uncivil people only, or tribal people only. So our roots are actually tribals only. And in case of ensuring any kind of intellectual property conferments or human rights enjoyment or technology sophistication, that should have effect at the grassroots. That means our forest areas or our tribal areas. So when our Adivasi people are having technology sophistication, when our Adivasi people's intellectual property rights are protected, when our Adivasi people's human rights are guaranteed, then only you can say that अच्छे दिन आए हैं, भारत वर्ष में अच्छे दिन आए हैं. Because Bharatvarsh has begun with it being tribal. When British people came here, they called Bharatvarsh to be tribal land. Even today, we are tribal land only. And all that knowledge, sophistication, Ayurvedic medicine or agriculture, everything is nothing but tribal knowledge only. So my appeal, while initiating this debate and session today, is that sophistication in any arena, in any area, can take place only when you have included, right, tribal populace in terms of formulating inclusive policy for the development of Adivasi through any mode or through any form. So my appeal is that intellectual property rights, human rights, and technology has to get in fusion, get in coordination to ensure that our Adivasi people are empowered, our Adivasi people are drawn into inclusive policy, and these things we need to remember when we go about drafting, formulating inclusive policy, that there is a serious fusion between intellectual property, human rights, and technology access as far as Adivasi empowerment is concerned. So with this few words, I will end here, and I would like to invite the other two speakers who are talking on some exclusive topics under the broader theme of Adivasis intellectual property rights and human rights. Thank you.
Thank you. Are you able to hear me
Thank
now?
you, sir, for enlightening us with such an important topic. It was really very important. Thanks a lot again. Now I'd like to invite Professor Gloria D'Souza to please initiate her talk. Over to Gloria, ma'am.
Thank you, Payal. Are you able to hear me now? Can you hear me now?
Yes. Yes,
Hello.
ma'am. You can.
So you're able to
Yes,
hear me
ma'am. We
now?
can hear you.
Okay, sure. Okay. Sorry about the disruption earlier. We have a huge snowstorm, and internet connectivity is very slow today. So I'm going to speak about patent and plant variety protection in the USA. So in the USA, plants are protected through IPR. And we have three main systems. And USA, in fact, is one of the first countries in the world to recognize plants as patentable. So it was as far back in 1930. So we had a Plant Patent Act. So Plant Patent Act only protects plants which are reproduced asexually. That means not through the seeds, but the plants produced through grafting or cutting, for example, roses. And the Plant Protect Act protects discoveries and inventions. So even if a person finds a new variety of plant in a cultivated area, he can seek plant protection for it. And also the people who actually create a new variety of plant through grafting or cutting or by using some technology can also obtain plant patents. And secondly, we have utility patents. So it was only later in 1930 the US added plant as patents, but before that there were like utility patents. So if there is any new plant that is new, useful, or non-obvious, and even the plants, those were created by seeds by using some sort of genetic engineering, can be protected this way. Plants, the Plant Patent Act protects only a specific kind of plant, that is the plant which is asexually produced. And then basically when US became party to International Convention on New Varieties of Plants, in order to confirm to the International Act, Plant Variety Protection Act was passed in 1970. So this act even protects sexually reproduced plant. So as long as a plant is new, distinct, and stable and uniform, it can be protected. So farmers were initially allowed to save seeds. So they were allowed to save seeds for their own use and also to sell them to other farmers. And then there are breeders. Breeders are basically breeders are private people, companies that produce the seeds. So they were also given the right to create other plant that derives from a patented plant. But later on, this protection was taken out. And a Plant Variety Protection Act did not protect hybrids. And along with these three important acts, there are also like other IPRs like trade secret, copyrights, trademark, and geographical indicators that Professor Srinivas talked about. They also protect the plants. So FI hybrids were earlier exempted, but there was an amendment in 1994, so that actually said plants such as corns, which are hybrid varieties, can be patented. So hybrids are basically the plants which were created through cross-pollinating of two different plants. And okay, so let me go back to the Plant Patent Act. So Plant Patent Act grants inventors of novel, non-obvious, or useful invention exclusive monopoly or a fixed duration of exchange, that is for about 20 years, to protect that inclusion. So earlier in the 80s, like in 1852, there were like important decisions like Leroy versus Latham, Le Arbitzer, whereby it was said anything no power of nature is patentable. And though bacteria is classified as a plant, it was said bacteria are not patentable. And in the earlier century, especially the private breeders, they started advocating for plant patents because they thought, and during that time, they were mostly breeding fruits and ornamental plants, and they actually requested U.S. Department of Agriculture, to basically to consider giving them rights. But during that time, the US was of the opinion that the plants are meant for public, so they don't want it to create monopolies. So their attempt to provide separate patents were not successful. But eventually, when Plant Patent Act was passed, most of the time they gave plant patent rights to different varieties of citrus, azalea, chrysanthemum, fruits like apples, grapes, and roses. So one of the requisite of a plant patent is that when you make an invention or when you discover a new plant, you have to provide a written description of it. But eventually, it was found it was very difficult to describe the plants, and that actually served as one of the detrimental factor as to obtaining plant patents. So when you get a plant patent, you basically get a right to exclude others from making, using, offering for sale, or claim. So as I said, according to this act, whoever discovers or asexually reproduces a distinct or a new variety of plant get the right to um, get a patent. But tubers like Jerusalem artichoke that you see it in the next slide, so are excluded from patent because it is like potato. The root is also genetic material, but at the same time, you can also eat it. So tubers were excluded. And the next slide, I'm showing you a rose plant. It is a climbing rose plant, and it was called New Dawn, and it was the first ever patented plant in America. It was patented in 1931, and it was discovered. It was actually invented by a farmer in New Jersey, that is the state where I stay, and this variety of rose is still very popular. Okay, so I'm actually referring to some of the important decisions from the court about plants being patentable. So in this particular case, Dennis versus Pitner, patentability was challenged when a person puts a patent claim on the basis of discovery. So in this case, Dennis discovered an insecticide that was actually it was basically an extract from a root of a plant. But in this case, the patent was not awarded to him because they said discoveries were there to encourage, the purpose of the patent law is to encourage discoveries and invention that is for the benefit of humankind. But they said only the person who first discovered can claim for a patent. And they said Dennis was not the first discoverer. Other people already had the knowledge about it in South America. And then later on, there was this case Reberji and later Chakrabarti. There were a lot of cases in United States whereby it was asked whether microorganisms or bacteria are patentable. And initially, the court went on saying that they are not, but eventually, in a landmark case, Chakrabarti in '79, they said that microorganisms are patentable. So now you see a picture of a lichen. Lichen is, not really considered as true plant because it does not have root, and so it doesn't have leaves. So it is basically a combination of a fungus and algae. So but later on, even fungi are more complex, more complex than a bacterium or a single microorganism, but they were considered as patentable. So when a person applies for a patent, there is some disclosure requirement. For example, in this case, Rayleigh Grice in 1962, the court said that when you seek a patent, the plant must be distinguishable from whatever plants which are already known. And then you have to explain how and where exactly you produce that, how asexually produce that plant. And if at all a plant was found or discovered, then you have to explain where it was discovered, and then you need to provide color drawings and photographs to show distinctive features of the plant. There is no need to provide a sample of the plant, but you just need to describe it. Okay, and and as I mentioned earlier, plant patents are limited because of certain requirements, like, there is a requirement like you have to provide a description. For example, a plant can be distinguished based on its flavor or describe it. And because of that, sometimes people won't be able to put proper claims for the patents. So, and also the plant patent holder has to prove there is an infringement, and then once a person applies for a plant patent, it takes about a year to 3 years to get the patent, because the process takes a long period of time. And especially if you are seeking a plant patent for a tree, you have to provide a lot of historical data that would take a very lengthy period of time. But despite of it, I have a picture of aloe vera, and there are actually hundreds of patents awarded, for things made of aloe vera, and things connected to aloe vera. So once the person gets a plant patent, he basically has a right to exclude others from reproducing his plant variety or offering for sale, or to reproduce or sell a part of, or to export, import the plant that is protected. And next, can we pass on to Yoder Brothers versus California? That is the next slide. Okay, so this is a case connected to infringement of plants. So there were a lot of ornamental chrysanthemum plants. So the alleged infringer has to prove that he independently developed the plant. So, only if you use the patented material to create your plant, then that will be considered as violation of patent. But if you discover it your own, even if it appears to be the one that is patented, then you cannot win that contention. Okay, so I would like to refer to one more case. It's called Imasio Nursery versus Coastal Nursery. So here, the Imasio produced a plant called the Sunset Heather. And the special characteristics of this plant is that it can bloom during winter as early as in December. And there were other varieties of heather plants already in existence. They usually bloom during spring after the winter, like around March. So they filed for a patent claiming that it is a different variety because it is not the same plant, because the blooming time is different. But the lower court actually rejected the claim, because they said if there is a plant already in existence or somebody has already discovered it, and if people keep on inventing, adding feature, what happens is then they put their own claims. Then the original patent holder cannot use it for his economic advantage, because one of the purpose or objective of intellectual property rights is that it should be of value to the person who holds it. But court's decision was actually uh, overtaken by, overruled by the appeals court, and they said that if you make your own invention, you can always claim a patent for it, as long as your invention did not derive from the previous owner of the patent. You can proceed with the invention. So this way, they actually recognized discovery as or innovation as one of the important aspect of patent right. Okay, so in the earlier years, it was always the ornamental plants and the fruits that were considered as important as far as the breeders. And also during that time, the US government was basically controlling seed production and distribution. And then even if they allowed the private people to sell the seeds, they had a restriction. And breeders did not like it because they wanted unrestricted freedom, and they wanted to conduct research, create new varieties, and sell seeds for their own advantage. USA is in fact one of the top country in the world, which is like a largest seed exporter, and the market is more than $2 billion worth. Uh, but later on, uh, the country started recognizing the breeders' right, and more and more rights were afforded for them. So the emerging trend is now not only the plants, but even many processes like ESTs, restricting enzymes, screening system, techniques related to DNA. So all these can also get the patents, because all this would eventually encourage us agriculture, because by using more technology you can produce more. Okay, and then the second variety of protection that is provided for the plants was through Plant Variety Protection Act. As you have noticed, the U.S. Patent Act provides plants produced asexually, whereas plant variety protection also provides protection to plants which were created sexually, that is through seeds. That is one of the changes brought forth by this act. So it is not easier to meet the requirement of patentability, like, to show novelty, disclose inventive step, and especially non-obviousness was difficult to, it was a requirement difficult to meet with. So US was not in favor of creating monopolies of seeds, but they did recognize rights of the breeders so that they can research, discover, invent new products. So United States Agriculture Department actually created a draft to recognize, it actually proposed a Federal Seed Act to drive plant breeders' right. Because in USA, for example, in India, it is usually the farmers, they produce stuff. But in US, you can also see small farmers or the farmers holding large acres of lands, and there are also private breeders which are involved in the business. So there was always a clash between the interest of private seed breeders as well as public seed breeders, and also the rights of the farmers. But US took into consideration a policy of taking into consideration everybody's interest, but US favors capitalism. So, so more and more what you see that is they're actually encouraging breeders, to have more patents, etc. Like basically they recognize their rights. So the objective of PVPA is to encourage the development of novel varieties of sexually reproduced plants and to make them available to the public, providing protection available to those who breed, develop, discover them, and thereby promoting progress in agriculture in the public interest. So remember, Plant Patent Act and Plant Variety Protection Act, they are different. Like Plant Patent Act basically protects, individual farmers as well as companies, whoever produce the plant. And a PVPA basically, it does recognize, farmers and breeders' rights, and it's more about protecting their rights and also protecting sexually reproduced plants, that is protection of plant. And this way it also protects genetically engineered seeds. So when you apply for a plant patent, you get a plant patent. So when you apply for your when you apply to protect the plant that you created, what you get is a certificate of plant variety protection. And this plant variety protection, just like patent, protects you for about 20 years. That is, you can basically, you cannot, you have a right against the infringement of your plant variety. And PVPA also recognize farmers' rights. So especially when a farmer grows crops for his own use, even if even if he uses some protected plants, that is allowed, because, and this is called as a farmer's exemption. But if other people, non-farmers, use that, they are not protected. And also there is another exemption called as a researcher's exemption. So even if you are using a protected variety, but for the purpose of research, you are protected. But so if you use a variety, protected plant without the owner's permission, or if you infringe their right in any other circumstances, you would be considered as you will be considered as violating rights of the individual breeders. And Patent Act excluded tubers, tubers like potatoes. So you can, under the Plant Patent Act, you cannot protect a new variety of potato. But under the PVP Act, you can claim protection for tubers also. People can apply for plant variety protection under Article 52 of the Act. So they have to name the variety and described it, like why it is distinct, and then they need to describe genealogy of the plant, how did you breed it, whether it was known, and provide adequate drawings and photograph. And also you need to provide a declaration about depositing a sample, and even plant specimens are required. So this is one of the main difference between Plant Patent and Plant Variety Protection Act, because under the Patent Act you don't have to provide the samples, but if you are seeking protection under this Act, you have to provide the specimens and samples. So the term of protection is 20 years. Wine like grapes, then you can get 25 years of protection. And then if any person who without the authority of the owner, of the person who holds the plant variety protection certificate, sells or market protected variety or imports or exports it, or if they try to multiply or propagate it without permission, they are they are infringing, and then the owner will have some redressal against them. So I think we can move forward. Remedy for infringement. Yeah, next one. Next. Yeah. So, okay. Next, yeah. I think next. Yeah, so remedy for infringement is a civil action for infringement, injunction, and also damages to adequately compensate for the infringement. So, according to the Act, if any person, yeah, I already covered it, sorry. So any person who without authority sell or market the protected variety, import or export. So basically any kind of infringement is considered a violation of Plant Variety Protection Act, and thus the owner of the plant variety can seek a judgment from the court for injunctions, or they can also claim damages. So we can move on. Next. Yeah. Next, please. Okay, so yeah, we covered this. So civil action for infringement, injunctions, and damages to adequately compensate the owner. Okay, so one of the important cases is in USA is Monsanto versus Bayer. So they said PVPA actually extends patent-like protection to novel varieties of sexually reproduced plants, which parallels the protection afforded to asexually reproduced plant varieties. So patent law, plant patents protect sexually produced plants, like asexually produced plants, whereas PVPA protects sexually produced plants. Okay, so I'm not going to speak much about trademark, trade secret, or geographic indications, since they're already mentioned. So see, trade secrets are opposite to, okay, let me mention about this. So in 1994, there was an amendment on PVPA. So the term for the protection was 18 years earlier, so that was extended to 20 years. And also the amendment prohibited selling of saved seeds of protected varieties without obtaining permission of the owner of the variety. So actually this act restricted the rights of the farmers, because earlier farmers had the right to save as well as sell seeds, but then this act restricts it that they can sell it only for somebody else's use, but if somebody else want to reproduce it, a farmer is not supposed to sell it. And this amendment also protected tuber plants that was not protected by Plant Patent Acts. Okay, So trademark, trade secret, and geographic indications actually provide some other protections. So take, for example, trade secret. Trade secrets are opposite to patents, because what happens with the patents, you get a patent, but after that 20 years, you have to disclose how to make, basically you get a patent because you have to disclose how it is made. So what happens after 20 years, anybody can produce it. But whereas if you are going to keep the trade secret, you just tell your employees, you contract with your employees and, uh, make them to keep it confidential, then, that secret can remain with you for a longer period of time. So, so plants can also be protected this way. And then another important protection provided is through utility patents. So utility patents actually provide a greater amount of protection because these are true patents. So so most of the time, protection is requested for the method of, the methods, processes involved in inventing a new variety of plants. So methods of treating and breeding plants, or all new inventions, genetic engineering, and so on. These are all protected under utility patents. And then the protection given by utility patent is much broader, because under Utility Patents Act, you can seek protection for seeds, you can seek protection for plants, and you can also seek protection for tissue culture. So this is something about geographical indicators here. Professor Srinivas mentioned about GI for Florida oranges and Idaho potato, etc. Because they are like distinguishedly cultivated in specific areas. So I will end here. So, so basically, in conclusion, what I can say is USA actually provides a lot more protection when it comes to innovation of new plant varieties. And, plants are protected through patents and plant variety protections and many other IPRs like trademarks, trade secrets, etc. So, yeah, so, and copyrights are also, copyrights can also be used to protection of a plant, in the sense, say, for example, how do you make that invention, the process, etc. They can also be copyrighted. Yeah. So that is all about it. Isaac, you can proceed.
Thank you, Gloria ma'am, for this very new and important topic and putting a very elaborate perspective on the very same. Thanks a lot again. Now I'd like to invite Mr. Isaac Emanuel to please initiate his talk. Over to Isaac, sir.
Thank you. Can you hear me? Hello?
Yes, sir. We can hear you.
Okay, thank you very much. Before I start my talk, I want to thank the Department of History and Political Science for inviting me, the organizers of this event, and thank you all for being here and listening. I'm gonna present you the talk titled Human Rights as the Basis for Software Development. Let me start the slides. Okay, so my approach to this topic is gonna be based on 5 principal areas: human rights, technology, software and machine learning, legal cases, and regulations. We may start asking ourselves, what are the most basic rights for a human person? The Dr. Victor Rodriguez have a definition that considers 3 main topics. They are those inherent to the human person, recognized by the state, and for all its inhabitants. In my own interpretation, I can add that they are basic laws for dignity. Also, they are not given, otherwise they could be taken. They are recognized by the state. They should be universalized. No discrimination is allowed. So what are human rights? It's actually a big concept because it depends on the legal philosophy of the country. It's not the same the human rights in Latin America, for example, or in Asia. But we can agree to some extent what should we consider as the basic rights of the person. In Europe and Latin America, for example, we have a concept that is human dignity. This concept was proposed by Kant, the philosopher, that was a rational natural law philosopher. It's based on ideas, principles, morality, that today it could be questioned by modern philosophy, but in this dissertation, we're gonna use it as the basis. It says that we should consider 2 main categorical imperatives: the universalization and treat humanity as an end in itself and not as a means. So when thinking about morality or thinking about a law, we should ask ourselves, for example, with slavery, could slavery be universalized? It doesn't seem logical because it wouldn't work, or societies wouldn't work. And also it treats humans as a means and not as an end in itself. So slavery shouldn't be considered when talking about human rights. We should have the human right to freedom. In simple words, we could say that Kant says, don't do to others what you don't want them to do to you. This could be considered the principle or the idea that Kant proposes. So which human rights do we have or should we have? We may use the Universal Declaration of Human Rights as the basis, even if it's not mandatory, because it's a declaration and not a convention or a legal treaty. We can agree that we all have rights to life, equality, non-discrimination, and freedom, even if there are several rights or the state can recognize even more, such as access to information or internet, for example. Okay, so the importance about human rights in this era is that we are entering the 4th industrial revolution, the age of artificial intelligence, and the main countries such as United States or China are using technology as decision makers. Technology is becoming not just a simple tool, but it also becomes a decision-making machine with algorithms and artificial intelligence. So it can violate human rights when it's made an illegal use or when it takes a decision that goes contrary to the human rights that we already recognized. We may need to first to clarify what we understand by artificial intelligence and algorithms. Navas and Goris give the concept that artificial intelligence is a field of science and engineering that deals with the understanding of, from a computer point of view, of what is commonly called intelligence behavior. We must not confuse intelligence in computers than intelligence in humans is not the same, because intelligence in computers is based on algorithm. Is based on probabilities, is based on statistics, and is not considering, for example, intuition or consciousness. Okay, so algorithms, in the other side, are a set of rules to solve a problem by reducing it to the simplest form. You give us an input to a computer, and the computer is translated to a set of rules to give an answer. So it's not the same. In the artificial intelligence, it's like a behavior, and in the algorithm, it's already set rules that will solve that problem. So we must see the legal cases that have arisen with this kind of technology to ask ourselves how we should regulate it. For example, in the United States, Apple launched a credit card in association with a bank that had gender issues. The users of this credit card started complaining that it seemed to give less credit to women instead of men. This was kind of arbitrary, because even if women earn more money or have a better credit score or have better income, they would still receive a less credit amount with Apple. This led to an investigation by the federal authorities, but to date it hasn't been solved. It hasn't been given a sanction or a legal consequence. This is an issue, and programmers should consider making their algorithms unbiased, because this can lead to violation of human rights. We're going to see several cases, such as an illegal use of the technology, such as in Hong Kong with facial recognition. In 2018, when the protests started in Hong Kong, the government started using facial recognition with cameras to identify the protesters by their biometrics. And this is worrying, because a totalitarian or authoritarian state could use this type of technology. I'm not judging the decision by the Hong Kong state, but it could be used by other states that want to oppress their citizens using facial recognition. And this should be considered a problem, because if we want democratic societies, if we want societies with freedom of speech and pacific protest, we should give the citizens the liberty to protest and to claim for their rights without having to worry about being recognized by cameras and being set on record or being prosecuted by the justice that sometimes can be unfair. We have a third case with Twitter. The social media can also violate human rights, and we should attend it. For example, the programmer Tony Arcieri discovered that in Twitter they have a big problem about their algorithm that is biased and is acting with racism. The programmer Tony Arcieri noticed that Twitter would crop the pictures that are presented in the post, so it can show the best area of the picture. And when presented with several people that are from a lighter skin and a darker skin, the algorithm would constantly choose to show the people with the lighter skin. This experiment was made with the persons Obama, the politic, and McConnell, and the algorithm constantly would choose to show McConnell instead of Obama because of his lighter skin. Also, to prove this further, they tried darkening the skin of McConnell and lightening the skin of Obama, and it showed the opposite results. The skin of the person that is whiter was the one that was shown in the picture. This is worrying because an algorithm of that social media should be unbiased, and if white people are getting more exposure, are getting chosen above black people, we can see discrimination. We can see that the algorithm is actually biased. So the third case is more worrying, and it actually deals with the human right to health. In the U.S. hospitals, they discovered the researcher of Meyer with some other researchers found out that the algorithm used in the hospitals would refer people with equal sickness to different programs of healthcare with complex necessities. I mean, if a white person and a black person have the same medical necessities, the algorithm of the hospitals that is widely used will refer the white person first rather than the black person. This is very worrying because it cancels the access to healthcare to black persons, and instead gives a preference to people based on their skin, based on a medical fact that should not be relevant when accessing healthcare. Actually, the hospitals of the United States, let me drink some water first. The hospital from the United States recognize this problem, and actually today they are working on it. They are working on with their programmers to correct this algorithm and make people available for healthcare problems independently from their skin tone. So here we have another example of discrimination against people, of sexism, racism, when considering artificial intelligence. Artificial intelligence is commonly trained with the text, the information that is commonly available on the internet, and oftenly it's not supervised. It's not the information that they give to the intelligence to be trained is not checked out previously. So if the information that is on internet is racist or discriminatory, then the intelligence will reply this kind of behavior. For example, when the intelligence was prompted with man or women, it would give two very different jobs. It would generate, for a man, it generated a text about a car salesman, but for a woman, it generated a text about a prostitute. So this is a problem about the text that is biased and is used to train the intelligence. Also, the black and the white man were given two different jobs: a pimp, a police officer, a judge, a prosecutor. This kind of bias should be fixed to have neutral algorithms and neutral artificial intelligence that eventually could take decisions that could make, for example, writing of news, writing of articles, or some kind of cover some kind of necessity for humanity. I'm sorry for that. So it was considered that it was discrimination against people with another sexual preference, such as a gay person versus a straight person. You can see the example on the screen, and it's worrying because in the further models of this kind of intelligence, we should consider giving it a text that is not biased, that is not, or actually that is supervised before using it, or make it so the artificial intelligence can correct itself, that it can detect this kind of bad behavior that violates human rights and correct it before being presented. So it doesn't make the same mistakes that humanity made before, because we humans made the text that is gonna input or further artificial intelligences. And also we have to worry about the military, because in December, 7th of December, the world was surprised with a news that the Iran scientist, that the nuclear leader of the Iran nuclear program, was killed using a machine gun controlled with artificial intelligence by satellite. This is worrying because we're starting a new era of augmented military with artificial intelligence. But what happens when this software or these kind of technologies are susceptible to vulnerabilities, such as hacking, malware, or software that could lead to mistakes? For example, if these weapons use facial recognition, what happens if it makes a mistake? If it harms the people that it shouldn't harm, would it be the fault of the machine? Would it be the fault of the programmer? Would it be the fault of the person that used it? So this is the kind of problems that we're going to face in the future, and this is the kind of problems that we should attend before they actually make harm to people and violate human rights in a massive way, especially if this kind of weapons or this kind of technology ends up in the wrong hands, such as in terrorism or people that break the law. If this type of technology ends up in this kind of people's, it could happen that they make crime without leaving a trace. The people wouldn't be able to know who made the crime, who committed the assassination, for example, because it would be very hard to trace a person that is behind a computer. So if weapons can be controlled from behind a computer and also without need of human intervention, it will be very difficult to trace people, even if for example, if it's in an international crime, it would be very hard to catch the person and make it pay for the crime that he made. So how can we deal with this, or how should we deal with this? We have international regulation that already recognizes the human rights. The document that I present you in the beginning of my dissertation is the Universal Human Rights Declaration. This document is not mandatory, but it works as a basis. With this document, we can then celebrate conventions such as the American Human Rights Convention, the European Human Rights Convention, or in Asia, they already have a declaration, but they may need to celebrate a convention about it. That is the Declaration of Human Rights of the Association of the Southeast Asian Nations. But we also may need international specialized treaties, because these conventions might recognize what human rights do we have, but also we may need articles to regulate this kind of technology specifically. We may need to regulate the military and the use of autonomous weapons. We may need to regulate the social media. We may need to regulate the use of facial recognition. For example, in social media, we all know that Twitter, Facebook, TikTok, every social media has its guidelines, community lines. But what happens if these community lines are harming people, are making decisions that violate human rights? For example, in most social media, they have algorithms, or they have decision makers that may censor someone, that may ban an account or close an account, and this may lead to the violation of the freedom of speech. People that don't agree with the speech that this platform have may end up banned or closed, and this is worrying. Or the videos that the platform doesn't like maybe getting down. So we may need international treaties specialized about the topic. For example, the Toronto Declaration. This declaration is the basis made by an international amnesty for protecting human rights in the age of artificial intelligence. This declaration is widely spread, and it can be signed by companies or it can be signed by countries to protect human rights in this era of technology or this era of information. So with this, I'm gonna end my talk, and I wanna end with a quote that is by an unknown author. Gaining knowledge is the first step to wisdom, and sharing it is the first step to humanity. Thank you very much, and I appreciate the time that you gave to me. Here are the references.
Thank you, Mr. Isaac. It was really wonderful listening to you. The technological development has seriously threatened the human rights. Thanks a lot again for enlightening us with your presentation. Now I'd like to invite Mr. Shubham Das to initiate the question and answer session. Over to Shubham, sir.
There are few questions in the chat box. I would like to invite Professor Cisneros, sir. Are you there, sir?
Yeah.
Okay.
Please.
SK, tribals are not even got their right to life, which is their only demand, and that only demand is also cannot fulfill for our so-called development is there. How the technology of our nation is growing, and I just also asked you question at the end. What kind of mechanism should the state provide for people in rural areas to access intellectual property rights? SK also added, we are talking of technology and they are living a life of our ancestors in Stone Age. We can teach them about technology, but we ignore it for just to maintain the class level between us. And this is the hidden truth we don't want to reveal. And how do we remove this mindset, sir? Over to you, sir.
Yeah. Rudhanaran, though I could not follow your question completely because there was some digital connectivity, but I still could make out what you were asking. Yeah, intellectual property rights, as I mentioned, the popular most belief is that it is, as I was talking in my, during my presentation as well, it is meant for only corporations and private individuals, but that's not true. We need to realize the fact that there is scope for our rural populace, tribal populace, forested dwellers. There is scope for getting their stuff protected under intellectual property. We need to get together for that. Individually, one tribal, individually, one rural folk cannot get protection. You have to get together. The entire rural folk should get together, tribal associations get together, then file applications under the respective, say, geographical indications law for your traditional products or for your folklore and things like that. Individually, it cannot happen. You have to get together as community. Right, so more hands to strengthen your cause. Likewise, if you get together as an association, you can obtain the protection. Not to venture into any city area or any multinational corporation, but only to ensure that nobody else is repeating what you are producing in your tribal rural area. Right, there shall be market for tribal products and rural products. Right, that can happen only when you prevent somebody in big cities also repeating the kind of stuff that you are doing, and the kind of stuff that you are doing is basically because of the traditional knowledge, tribal knowledge. You have not acquired that knowledge from colleges, university, right? So it is from your previous generation. Your ancient people have given you that that knowledge. That knowledge you are using and producing some products. And other people, by copying that, they are going on a big scale, industrial scale. That you have to prevent. right? By copying the traditional knowledge of yours, the people are going on mass production, industrialization. Like, for example, I'll tell you, when basmati rice is India's, right? From Punjab region of India, some rice tech company happened to copy it and happened to come out with a genetically modified rice variety. They called it as Texmati and started growing. I mean, started selling it across the globe. We realized only when our basmati exports started to go down, then only we realized that somebody copied it. Why they copied? Because you are not protecting, that's why they copied. Later on, you realize that, and you protected the basmati rice, and nobody except the Punjab Farmers Association or tribal areas of Punjab, except that nobody else can grow now basmati. Even if you grow, you cannot call it basmati. That's how you have cemented market for your product. Likewise, you have to ensure that by getting together in the form of a community association or a group, you should get your stuff documented, you should get your product protected so that your product becomes, garners some goodwill and it gets some market so that your lifestyle, your livelihood, your life standard also grows. Prevent piracy of your work, your stuff by the big multinational corporations or other people. That's what is required to be done. Then only the rural populace, tribal populace can make use of IPR and they can grow, they can join the mainstream economy. When I say again, joining the mainstream economy is not leaving your tribal area and coming to Bhubaneswar. That's not my cause. I'm talking about ideological joining, not leaving your areas and migrating to some other area, big cities like that, right? My friend from Mexico must be having an idea. You have different tribal areas in Mexico as well, and leaving those places and coming to say city Mexico, or my friend Gloria must be having an idea to understand that different places such as Arkansas and Alaska in USA, right? There you have tribal populace, and I'm not asking them to migrate to New Jersey or New York. That's not the mainstream joining I'm asking. I'm asking about ideological joining, not physical joining. That you can ensure only when you can see that your culture, your heritage, your product is not pirated by somebody else. For that to happen, you have to get together. Right? If not through the usage of technology, it can be done by your collective efforts of you getting together. And when you ask about technology usage, I'm not asking to impose technology on some tribal populace. If tribal populace is willing to do that, then only you can give them. I give an example also. We talk about 4G, 5G now. Because of COVID, no classes are taking place for any of the schools and colleges. People in cities, kids of those parents who are in cities, they are utilizing this 4G, 3G technology and they are able to attend the online classes. But what about those areas where there is no internet, where there is no your 3G, 4G? Then those children, those kids who are also supposed to get online classes, they are unable to do that. Right? Then don't you think that there is a need of extending this technology sophistication to those areas where our tribal populace is living? Don't they have any right to get education? Don't they have any right to have access to online classes? Not only online classes, anything that is happening now, even before your television, radio, or your newspaper reaches online, the information is reaching. Right? Can't they get to know about the latest happening through internet? Can't they attend the online classes? So the contemporary example I'm giving, technology is required for meeting the daily needs. Especially in the wake of COVID, you need to have technology or your internet access so that everybody, including the tribal areas, tribal populace, forest area people also can have access to internet or attend online classes or debates like this. Why should we confine only this kind of intellectual debates or information supply or classes only to the people who are in cities? Why can't we do the same with tribal populace, forest dwellers? That's the reason why I said technology sophistication, technology assistant, technology support is required, not for letting them join the cities, but to give them the minimum. Nowadays online classes is the new normal. Everybody needs that nowadays. Online news or internet connections is the new normal. It's not sophistication, it's no more luxury. So I'm asking about those basic minimums, like we talk about cloth, food, and shelter to be the basic minimum. Nowadays technology assistance is also becoming a fourth basic minimum, right? That's what I intended to say.
Thank you, sir. Very nicely responding to our questions. I would like to invite Gloria D'Souza, ma'am, to respond to questions from the side of our participants. Ma'am, could you please unmute yourself? Gloria ma'am. Okay, now I would like to invite uh, Isaac sir to respond our questions.
Yes, could you make the question?
Yes, yes, sir. Just a second.
Yes, Isaac. Can you hear me? Hello.
Yeah, I can hear you.
Isaac, do you agree with me? What kind of protest you are mapping in particular human rights violations in USA and India? What is your basic ideas and observation in terms of this human rights violation related to farmers' protest, even activist kind of protest, even industrialization protest? Please, can you share some of your internal ideas about human rights violation?
Okay, I don't know if I heard the question correctly. What kind of protections should the state grant to the protesters? If it's so, I think the state should recognize freedom above everything. Like, it's a human right that every person should have, and the technology should be regulated. I don't think it should be banned or it should be misused, because technology always takes the lead to regulation. So we should use this technology to our advantage, not to oppress, not to make the citizens feel, not to violate human rights of the citizens. So if this technology is used, it should be, for example, to prevent protesters that are using violence to further these conducts. For example, in the United States, we have seen that many protesters have been using violence to defend their ideologies, and this shouldn't be legal. For example, vandalism shouldn't be allowed, and we can use this kind of technologies to prevent these crimes from happening, but we shouldn't use it to prevent freedom of speech or to violate human rights. This is why international treaty or internal legislation should be used and should consider human rights when talking about this topic. Also, programmers should take in consideration human rights when writing their programs, their algorithms, and not only interest from the companies or interest from the government. I don't know if this answers your question.
Thank you, sir, for responding our questions.
Sinu sir, can I ask one question to you, sir?
Thanks all the participants to answer the questions. And thanks a lot, Shubham sir, to initiate the discussion forum. As the session has started, it has to end. So to end the session, I'd like to invite Mr. Shubham Das again to conclude the session by giving vote of thanks. Over to Shubham sir.
Excuse me,
Thank you, ma'am.
Shubham sir, can
Very good
I ask?
afternoon to all.
Yes.
It's
Can I
my
ask
immense
one?
pleasure to go for a formal vote of thanks for this session. First of all, I would like to thank our esteemed guest speaker, Professor Gloria D'Souza, Professor Isaac Emanuel, and Professor Cisneros for enlightening us today through their ideas on their said topics. I extend my hearty thanks to Dr. Vikram Kesari Jena, Director of CAD, Odisha, and Chinmay Sir, Executive Director of CAD, for their cooperation to organize this event. I would like to express my profound gratitude to our Principal Professor Pallav Chakravarti for his cooperation in organizing this webinar. I would also like to thank Convener Professor Saraj Chandra Pradhan, Coordinator Udar Narayan Das, Co-Coordinator Payal Agarwal, for their support and guidance to organize this webinar. I am happy to express my vote of thanks to all the participants, including academicians, students, media persons, civil society members, who have made this webinar a grand success by sparing their valuable time with us. Our next session will be at 4 p.m. today. I am requesting all participants to remain present and keep connected with us through our official WhatsApp. Thank you. The meeting is concluded now.
Thank you. Thank you very much. Thank you, Isaac.